Court rise for District Judge Edwards.
Please sit. Yes, Ms. Yare, this is your case?
Yes, sir. May I introduce my witness? Or
yes.
you want me to summarise the fact to start with?
Well, so I know that you're on behalf of the claimant, that's right?
Yes.
Mr. Webb, you're on behalf of the defendant?
Yes, sir.
Right, I can tell you both I've had an opportunity to quickly flick through the case summary, the witness statements. I have seen both of your skeleton arguments as well. As you are aware, we're in a very busy list, so I am going to keep things short and snappy. We have an hour to get through everything, so I expect you both to use your discretion in cross-examination and in your closing remarks. Otherwise, Ms. Yare, this is your case. Please proceed.
Mr. Claimant, could you please tell the court your full name and address, please?
Yes, it's Colin Clement of 97 Brick Lane, Bristol.
Could you please turn to page 21 of the bundle, 20 of the bundle, please? Is this your witness statement?
Yes.
Could you turn to the next page? This page. Is that your signature at the bottom?
Yes.
Have you had any opportunity to read your statement recently?
Yes.
Is there anything incorrect that you would like to amend or draw the court attention to?
No.
Is the content of that statement true to your knowledge?
Yes.
Mr. Claimant, I do not have any further question for you, but my learned friend, Mr. Webb, would ask you some questions, and if you can remain sitting.
Yes, can I ask you to turn to paragraph 12, please, of your statement? We're at page 21. And we can see there that on the 14th of April 2018, you were away on a weekend break with your family. The defendant telephoned you, said she'd been to the property, didn't think you'd done anything since she had visited 2 weeks earlier, and then an argument ensued. Things got a bit heated in that telephone conversation, is that right?
Yes.
And the substance of that argument appears to be the defendant's belief that you haven't done any work for at least 2 weeks. Was that right?
That was her belief.
And at the conclusion of that conversation, she said to you, and we're still at paragraph 12, last line, that the contract was over and I shouldn't go back to the property on Monday. Do you recall that?
Yes, I do.
Now, that call comes against a backdrop, if I can put it that way, of some disagreements between yourself and Miss Fender. Is that right?
Yes.
Those disagreements, if we look at paragraph 11, chiefly concern delays that Miss Fender had perceived to be occurring in the construction of this property, correct?
Yes, she did believe there was a delay.
Mr. Webb, if I can just stop you there. I'm getting a bit old and a bit hard of hearing. If you could raise your voice a bit, please, I'd be grateful.
I'm grateful, sir. Thank you. Well, let's turn to paragraph 7. It's the page back, page 20. Very first line of paragraph 7. Your understanding was that you were to complete this build within a reasonable period of time, correct?
Yes.
Right. Now, Miss Fender, it seems, we've just looked at the backdrop, clearly didn't think works were progressing at a reasonable pace. Do you accept that?
She didn't believe, yes, that they were progressing at the right pace.
Right. And then it looks like things come to a head, and that's the backdrop to this conversation on the 14th that we've just looked at.
Yes.
You say a reasonable period of time, we're staying on paragraph 7, is approximately 7 months. Do you stand by that today?
That's what I projected the work would take when I first undertook it.
Well, we'll come to that point, actually, about what you projected when you first undertook the work in a moment. But just focusing for now on paragraph 7, the last sentence, I thought it would take approximately 7 months to complete the work based on my experience. Is that what you maintain today, that 7 months is a reasonable period of time to complete this schedule of works?
Yes.
I'm sorry, Mr. Clement, you can't confer with your barrister. It has to be your evidence and your evidence alone.
Yes.
That was yes, wasn't it? Well, let's turn to that point then about what you projected at the start. Guess a quote. That's a company that you use in your line of work.
Yes.
And Guess a Quote, as I understand it, tell me if I've got this wrong, projects a period of time in which a project is going to be completed.
Yes, it does.
And in this particular case, if we look slightly further up at paragraph 4, Guess a Quote predicted that this project would take 90 working days.
It does, yes.
We have a copy of the back sheet to the quotation that refers to the 90 days. I'm not intending to take you to that, but do let me know if you'd like to go to that at any point. All right? Okay. Now, you say the Guess a Quote projection isn't accurate. 90 days is not a reasonable period of time to complete this set of works.
No. Guess a Quote is based on multiple people working at the same time on different projects, whereas I'm a sole contractor, which the defendant was aware of.
And I think you say that the problem with the Guess a Quote estimate is not just limited to the fact that certain works are overlapping and that you're a sole trader, but also that it doesn't take account of delays and such like.
Yes.
Can I ask you to turn to paragraph 9, please? This is on page 21. Those delays that we're talking about are delays for bad weather and delays due to not having a mains power supply at the site. Are those the delays that increased this projection from 3 months up to 7?
Yes.
In addition with the overlap of the work?
Yes.
Well, let's talk about the power supply for a moment. Power supply presumably to your tools that you use in the construction of this kind of work?
Yes.
Right. Your power supply is presumably not required if your tools are petrol operated.
Yes.
Help me on this point then. The tools that you used in this job, were most of them electrically powered or were they petrol powered?
Some were electrical, some were petrol.
Staying on this point about power supply, is it not the case that you were told there was an alternative power supply available to you?
I was not told.
Now, in addition to the point about power supplies and bad weather, it seems as though some of these delays arise from holidays that you were taking during the course of these works, correct?
Yes, which I informed the defendant of in advance.
Well, let's look at paragraph 10, because that's where you cover this point, and this is in particular the holiday to Australia over Christmas 2017. Is that the holiday that you're referring to?
Yes.
And you mentioned that you had informed the defendant of that holiday when you quoted for the work. Had you mentioned to her how long you would be on holiday for?
No.
How long were you on holiday for? Was it 3 weeks?
I was out of the country for 3 weeks, yes.
Turning back to that point about the initial quote of 90 days, 3 months, and your estimation that 7 months is a reasonable period of time, as I understand it, and again, feel free to correct me if I'm wrong, you say that that 4-month discrepancy between the 3-month quote and the 7-month quote allows for delays due to bad weather, holidays, lack of a mains power supply, and some overlap of works.
Yes.
Let's turn briefly to that estimation from Guess a Quote at page 3. Now, I think I understand what this is showing us, but tell me if I'm interpreting this graph incorrectly. Where we see those black bars, we see the time estimate or the working day estimate for the corresponding piece of work on the left, correct?
Yes.
Now, where those bars appear above one another, that shows a degree of overlap.
Yes.
Well, Looking at the degree of overlap we see here, and specifically looking at the working days, is it fair for me to suggest that what we're looking here in terms of overlap is probably no more than 20 or so days?
If this was a multi-person build, yes, but as I work as a sole contractor, there are some things that take longer for me to do.
Well,
Mr. Webb, it might be me being stupid, but where do you get 20 days from?
well, I appreciate it's a somewhat rough and ready estimate, looking at the 0, 10, 20 and continuing up.
Thank you.
What the defendant says is this. 7 months is just simply not a reasonable projection for a schedule of works like this. And 3 months is simply far closer to the mark, as we see on this guess-a-quote estimation. And even being charitable to you and allowing an additional 2 months on the guess-a-quote estimation, bringing us up to 5 months, we're still far off the mark of what you estimate as a reasonable period of time. So let me ask you this. Do you say 5 months is a reasonable period of time or not a reasonable period of time to complete these works?
No, 7 months would be reasonable.
Do you accept, though, that had you started work as planned in August and had it taken you 5 months or so to complete these works, Miss Fender would not have had to move in with her parents in late February, early March?
If I had completed the work in 5 months, the client would not have had to move in with her parents, but this wasn't something we ever discussed.
All right. A few more questions, if I may, so I appreciate that there's a busy list. You recall receiving an email from the defendant, don't you, on the 16th of April?
Yes.
And that confirmed the substance of the phone call on the 14th of April?
Yes.
That was sent to your email address. Presumably, you had communicated your email address to the defendant at some point during this contract?
Yes.
Okay. It looks as though, and again, tell me if I'm wrong on this, you have accepted that you are under an obligation to carry out these works within a reasonable period of time. Where we disagree is on the duration.
Yes.
Do you also accept that you are under an obligation to carry out those works to a reasonable standard of care and skill?
Yes.
Well, let's talk about those works. You have seen Mr. Smith's report, and Mr. Smith identifies that there are some £5,000 of remedial works to be undertaken to this property, in addition to some £5,000 of completion works. Do you recall that?
Yes, I've read the report.
Do you accept that the fact that Mr. Smith has identified £5,000 of remedial works needing to be undertaken on this property rather suggests that some of the works you completed were not up to that reasonable standard of care and skill?
As with any building project, there is always a period of snagging at the end. So one thing might damage another during the build, which would then need to be fixed at the end. All the work would have been completed and the house would have been to the standard that we had agreed had I been allowed to finish the build.
Well, if I can take that just step by step and summarise it, are you saying that the £5,000 worth of remedial works identified are simply matters of snagging?
Yes.
All right. You had blueprints from a Mr. Pringle to build this property, and it was on the basis of those blueprints that you quoted.
Yes.
You were aware, I take it, that the property you were going to be building was this defendant's dream home.
Yes.
This wasn't just a run-of-the-mill bricks and mortar project. It was a project to construct a dream home. Would you accept that?
I treat every property I build with equal care.
It's not so much a question of whether or not you treat each property with care, but rather this wasn't, for example, a commercial building or a block of flats for any resident to live in. It was a contract to build a dream home for someone, and therefore wasn't the norm. Do you accept that or do you deny that?
It is not the normal job that I undertake, no.
And the reason this is not a normal job is because of the quality of the building that you are going to be constructing being a dream home. Yes?
I always construct high quality buildings.
Well, let me ask you this. Given, forgive me, sir.
Mr. Webb, do we have much more?
The final question, if I may, sir. Well, given that you were constructing a dream home, do you agree or disagree that what you were providing in your services was not just a matter of bricks and mortar, but in fact providing something that would ensure the peace of mind and the enjoyment of Miss Fender?
I always strive to provide that to my clients.
Sorry, unless I can assist you any further on this, no further questions.
No, thank you. I have one question, if I may. This 7 months that you think was a reasonable period, does that include the various delays you complain about? Or is that exclusive of the various delays you complain about?
It is exclusive of delays such as lack of power and poor weather.
Thank you. Any questions arising from that?
No, sir.
Any re-examination, Monsieur? Thank you very much, Mr. Clement. And I assume that is the claimant's case, is it?
Yes, indeed, sir.
Thank you.
Well, sir, I'd like to propose to call Miss Fender, but before I do, I wonder if you might entertain an informal application to chief some matters from Miss Fender.
What exactly do you propose to ask her about?
Specifically in relation to quantum.
So you're basically asking me for permission to ask some additional questions of Miss Fender about matters which aren't in her witness statement, that's right?
Yes, in order to expand upon matters that are within the witness statement already.
And they are presumably to attempt to get around the complete lack of evidence of quantum for your client's counterclaim. Would that be fair?
Well, one might characterise it as getting around a lack of evidence, so I prefer to characterise it as assisting the court by providing further evidence.
I see. Ms. Yebb.
Obviously, the claimant would object to this application, given that it was last minute, almost like ambush, and we didn't get a chance to consider further evidence, which should be included in the trial bundle.
Yes, Mr. Webb, I'm going to deny your application. There were fairly standard fast-track directions that witness statements needed to contain all the evidence that wished to be relied on, along with disclosure. That's clearly not happened in this case. You're going to have to proceed with the evidence you've got.
Right. I'm grateful, sir, in which case I propose to call Miss Fender. Miss Fender, can I ask you to turn to page 22 of the bundle of documents before you? Now, before we look at that document, would you please confirm your full name and address?
Danielle Fender, 96 Strawberry Fields, Bristol.
The document we're looking at page 22, do you recognise that to be your witness statement?
I do.
If we continue over the pages to page 24, you'll see a signature. Do you recognise that signature?
Yes.
Is it your signature?
Yes,
Have you had an opportunity to recently consider this witness statement?
I have.
Are the contents of this witness statement true to the best of your knowledge and belief?
Yes.
Is there anything further that you wish to add or clarify to this witness statement?
No.
So may that stand as the evidence in chief.
Yes, Ms. Yebb.
Ms. Fender, in 2017, you contact the claimant to give you a quote for the construction of your house. Is that correct?
That's correct.
The claimant produced a schedule of work, which is at page 3 of the bundle, with an estimate program and quotation of £125,000. Is that correct?
That's correct, yes.
And the estimated duration was 90 days in this case. Is that correct? You then signed the contract with him on, if I can ask you to turn to page 4 of the bundle. You signed the contract on the 30th of June 2017.
Yeah.
Did you check and agree the term before you signed it?
Yes, I did check the contract before I signed.
And you included the fee clause of the project in clause 7. Is that correct?
Yes.
But there was no clause for specific completion date. Would you agree?
Yeah, I would agree.
You didn't specify that the project need to be finished within 90 days, did you?
Not in this contract, no.
You didn't specify that the project need to be finished before 28th of February 2018, the expiry date of your tenancy agreement, did you?
No, to be honest, I didn't think I'd have to.
You would agree with me if you would have put those clauses in if you consider them essential.
Yes, that's correct, but this isn't something I do regularly.
Ms. Fender, the truth is you did not specify that the work must be finished within 19 days or before 28th February because you know it's only estimation.
Yes, it is an estimation, but there's quite the leap between 90 days and what it actually took it being 7 months.
Ms. Fender, you obtained building permission before you hired the claimant. Is that correct?
Yes, I did.
The claimant was your builder but not project manager. Is that correct?
Yes.
So he would not be responsible to get the build over notice, would he?
No, he was aware of that.
But my question is, was he was not responsible to get the build over notice. Is that correct?
Yes, that's correct.
It was your responsibility.
Yes.
And it took 4 weeks to obtain the notice.
Yes, that's correct.
So the project actually couldn't start until you obtain the notice.
Correct.
Ms. Fender, the truth is the lack of build over notice delayed the project and it was your responsibility to get it. Is that correct?
That is correct.
And this project was to build the house from scratch, which is in clause 1 of your contract at page 4.
Mm-hmm. Excuse me.
Is that correct?
Yes, that is correct.
So you would agree with me the electricity was not connected when the project started if it's something built from scratch.
Yes, that's correct, but I'd come to an arrangement with my neighbour.
I'll come to that point. And you were aware of this, and the claimant told you repeatedly he had no access to electricity. Is that correct?
I wouldn't say it was a repeated claim from him.
Were you
I was
aware?
aware. I was aware.
Because he has no access to electricity for a while, so he couldn't use any of his electrical tools. Is that correct? If there's any tool, electric, he couldn't use it.
Yes, if he has no electricity, he can't use it.
So at the end, he had to use your neighbor's outdoor plug in able to use the tool. Is that correct?
That is correct. That's what was agreed.
Ms. Fender, the truth is there were delay for you to negotiate that position with your neighbors, and that delayed caused further delay of the claimant's project starting. Is that correct?
Well, it took 4 weeks to get the notice to get the property built. You know, I had time to negotiate with my neighbour and arrange the electricity. I just feel that it was more excuse after excuse for Mr. Clement.
Ms. Fender, you know that you need to give the claimant 10-day notice before you can terminate the contract under clause 4, which is at page 5 of the bundle. Is that correct?
Yes, that's correct.
But when you called him on 14th of April, you told him you terminate the contract immediately. Is that correct?
That's correct.
And you told him not to come back during
Yes,
the phone
it was
call.
quite an emotional reaction, but yes, I did tell him that.
When you wrote to him on the 16th, 2 days later, you confirmed that the contract was terminated with immediate effect. Is that correct?
Yes.
You would agree with me that immediately means now.
Yes.
So you didn't give him 10-day notice at all.
No, I didn't.
Ms. Fender, you would agree with me that the contract was not terminated under Clause 4 because you did not give him 10-day notice.
That's correct.
Ms. Fender, before you wrote to the claimant on the 16th of April, you changed the lock of the property, didn't you?
Yes.
You changed it so the claimant could no longer access the property.
He was barely there anyway. But yes, I did. Sorry, I did.
You did not want him to access the property because you consider the contract terminated on that day already.
Yes.
Even if he wanted to return the property to finish the project, he couldn't. Is that correct?
Yes. No, it could have been finished in 10 days. But you are right, he couldn't have got back into the property.
You removed his tools and materials from the property and put them on the road.
I left them outside the property.
They were exposed in public without any protection. Would you agree with me?
Yes.
May I refer you to Clause 21 of the contract, which is at page 7.
Ms. Yeah, before we go there, is there a claim in relation to the tools at all?
We considered that by putting the tool outside, which is a repudiatory breach, and by retrieving that, we accept repudiatory breach. Therefore, the contract was terminated by the claimant rather than the defendant.
I see, but there's no monetary claim.
No,
for the tools.
not at all.
Okay, thank you.
Would you agree with me, Ms. Fender? Even if you consider the contract was terminated, the claimant would still be entitled to recover from the property of his materials and tools.
That's correct. Yeah, I do agree. But we'd had quite an argument on the phone as well, and I just left him out in the street, and it was a reaction, really.
Ms. Fender, I suggest that you were in breach of Clause 21 by putting the claimant's tool and material outside the property on the road. Would you agree?
Yes.
You did the remaining work yourself and with assistance of your friends. Is that correct?
Yes.
None of you were builders, I assume. Is that correct?
Not officially, no, but a few had developed their own properties, their own houses.
You would agree with me, it would take longer for non-professional to do this than hiring a professional.
Well, one professional against 5 non-professionals.
Given that you are not professional trained, it's possible you would make mistake during your work. Would you agree?
Yeah, it's possible I could have made a mistake.
And Mr. Smith's report was done after the house was completed. Is that correct?
Yes.
Therefore, he didn't have a chance to visit the property when the remaining work were not carried out. Is that
No,
correct?
because the house had to be finished.
Therefore, there will be some error in his report regarding the value of remedy work because he was not there to evaluate accurately.
There could have been error, but it could have been either way. So.
And the claimant has never got chance to take photo of the actual status when he left the property because you denied his access, isn't it?
Yes, but as a professional, he should have been keeping an eye on the job as it was going on, especially having left it to a family member while he went on holiday.
So I have no further questions.
Thank you. I don't have any questions. Do you have any re-examination, Mr. Webb?
No, sir.
And I assume that's your case then, Mr. Webb?
Yes, indeed.
In which case we move on to closing statements. I should say I've seen the report from Mr. Smith. My understanding of that, and you'll correct me if I'm wrong, Mr. Webb, is that that's based on photographs taken by your client prior to any works being taken out.
Yes, that is correct.
So we do have some photographs of it as it was roughly left by the claimant.
Prior to the £15,000 of remedial works being taken out.
Yes. Thank you. Yes, Mr. Webb.
Well, sir, I'll start on the first matter in issue, which is whether or not the contract has been terminated, and specifically in accordance with Clause 4, and I'll make 3 points. The first is this. The contract was terminated on the 14th of April, and it was terminated at common law following the claimant's repudiatory breach of contract in failing to complete these works within a reasonable period of time. There are 2 brief questions to consider, one of law and one of fact. The one of law is whether or not there was a term to complete this within a reasonable period of time, and in my submission that is made out on this case as indeed acknowledged by the claimant in evidence today. It was clearly a term that went to the root of the contract, sir, and I say that because when one looks at clause 26 of the contract, which is at page 8,
yes,
one sees that...
I'm sorry, page 8.
Page 8.
Thank you.
Clause 26.
Yeah.
One sees the parties may not have included a date for completion in this contract, perhaps bizarrely, but had recorded at clause 26 that time was to be of the essence. And therefore, it's the defendant's submission that the term which ought to be implied as to these works being completed in a reasonable period of time went to the root of the contract, breach of which was therefore capable of being a repudiatory breach.
Well, do you say that there was a specific time incorporated into the contract, 90 working days or any other time?
No. So I don't think in all seriousness I can attempt to suggest that 90 days was
Right.
incorporated into the contract, not least because there is an entire agreement clause later in the contract. It is a question of fact in my submission what a reasonable period of time is, and that is where there is the major discrepancy between the parties. Mr. Clement, of course, the claimant says it's 7 months after the fact, and then we have the guesser quote that says it's 90 days or 3 months. In my submission, forgive me, sir.
Wouldn't it be an objective test rather than a subjective one as to what a reasonable time to complete would be?
Well, indeed, and to assist the court in reaching that determination, there are only 2 pieces of evidence. One is from the claimant, a builder, and one is from a website whose function, it appears, is to recommend timeframes for completion of works.
No expert evidence on this, which would have been helpful.
Sadly not. It may well have been prudent for the parties to have asked Mr. Smith to comment upon this point. It seems that hasn't happened.
All right. And it's 90 working days, isn't it? So it's not 3 months. It's somewhat longer than that.
Well, yes, indeed.
Go on.
Well, so continuing on this point as to termination on the 14th, that there is a serious discrepancy between this 3 months, 90 working days, and the 7 months that have been proposed by the claimant. And what the defendant says is that somewhere in between the 2 is where a reasonable period of time lies. And even being charitable to the claimant and allowing for some period of 2 months or so for unexpected delays according to weather, delays according to the lack of an electricity supply, which I should point out was available to the claimant, we still get up to a period of around 5 to 6 months. It still falls short of what the claimant tells you today a reasonable period of time is. It was in frustration, and in particular the fact that works hadn't been completed for some 2 weeks prior to the call on the 14th, that call was made, and in essence, the breach that had occurred, breach of that term as to a reasonable period of time, was accepted as a terminating event on the 14th of April, and therefore the contract terminates on the 14th. Alternatively, sir, the contract was terminated on the 16th of April, at which point an email had been sent to the claimant confirming the conversation on the 14th. The termination would occur forthwith. That is in part compliance with Clause 4, insofar as the email is in writing. It is not in compliance with Clause 4, insofar as it doesn't purport to give 10 days' notice. A question of law arises as to whether the failure to give 10 days' notice invalidates the provisions of Clause 4, or simply gives rise to a breach claim, in which case the damages are damages associated with a 10-day period of time that the claimant would have had but for the failure to comply with Clause 4. And so we say that the term requiring a 10 days notice period, having not been complied with as accepted by the defendant, does not invalidate the notice that was given, and therefore termination is still effective on the 16th, but rather gives rise to a claim in breach. The third argument is this. Alternatively, the contract was terminated on the 26th. And that argument is predicated on the email that purports to terminate forthwith, in fact giving 10 days notice. Now, sadly, we don't have a copy of the email before us, so it's accepted that the email did refer to termination forthwith.
Fine. So you've given me 3 different dates.
Yes.
What difference do they make?
Well, the one in alternative to the other. The difference in the main part relates to the damages that this claimant can seek to recover for the failure to comply with Clause 4.
Go on.
Well, on that point, I'll make one brief point, which is that if the court is of the opinion that the claimant is entitled to damages for that 10-day notice period that was not complied with,
Yes.
the court is at somewhat of a loss, I would suggest, as to how to quantify that. It's not clear that any indirect loss arises by that 10-day period not being afforded. It's not clear that any direct loss arises because the 10-day period doesn't have, I'd suggest, intrinsic value to it. And so even if it is the case that the claimant can make out breach of contract, the quantification of that breach is just simply not an endeavour that the court can pursue. And so the value is de minimis or nil.
Right. Okay.
As to the counterclaim, the position is...
Okay, but hang on a sec. But we know that he was paid £110,000, don't we?
Yeah.
Just checking. And we know that Mr. Smith says that there's £10,000 of work left to do, of which £5,000 is finishing work.
Yeah,
So isn't he entitled to something for the work he's done between the last payment and when the contract was terminated?
Well, in short, we say no, because there's no provision in the contract that speaks to what happens in the event of a termination that would perhaps give rise to such a claim. And so if I can just pause on that point, at its highest, if the claimant is to make out breach, and if the court is not of the view that damages ought to be quantified as the loss of a 10-day notice period, the sum claimed of £15,000 is not reasonably the sum that can be recoverable, given that even if the claimant is to be remunerated for the loss of works done, there are £5,000 of works outstanding, and so at its height, the damages are £10,000 only.
Okay, thank you. Counterclaim.
Counterclaim, very briefly, sir, as
Yes.
I appreciate you do have a busy list. We say there are 2 implied terms. I've already addressed the court on the implied term as to completion within a reasonable period of time.
Yes.
We say there was a like term to complete this work to a reasonable standard of care and skill.
Yes.
That second term has not been complied with because Mr. Smith has identified that £5,000 worth of remedial works need to be undertaken.
Yes.
And therefore a claim arises therein. The most pressing point on this, or the point at which I would suggest most submissions are required, is as to general damages.
Well, so I presume then you're not going to push very far with your claim for £15,000 when Mr. Smith says there's £5,000.
Well, the point is this, if I may, sir. We do maintain that because the £15,000 remedial works have arisen as a direct result of the claimant's failure to complete these works within a reasonable period of time and to a reasonable standard of care and skill. Now, it may be that my learned friend wishes to suggest there has been some failure to mitigate because Mr. Smith identifies these works could be completed for £10,000 and in fact £15,000 worth of works have been incurred.
Well, actually, what we have is the defendant saying £15,000 worth has been incurred. We've got no evidence at all of that, have we?
Indeed, and regrettably it was a point that could not come out in chief earlier today. There is, of course, evidence on this point insofar as there is a sworn statement
Yes.
from the defendant to that effect, and no evidence as I can see or as was raised in my note to suggest that those works were not incurred.
Very well. So you were going to talk to me about general damages.
Yes.
Go on, Mr. Webb, persuade me.
Briefly, sir, what the defendant says is this. This was not just a contract to build a home, it was a contract to build a dream home. And therefore it is not the standard brick and mortar contract, as you may have heard me refer to earlier. It is in fact something different. It is a contract where, if not a major, at least an important component was the provision of something to the defendant that would ensure her pleasure and peace of mind.
Just humour me for a moment and pretend I don't know anything about general damages in contract. The general rule is that you can't recover general damages for a breach of contract?
Indeed, sir. An accurate summary of the law, if ever there was one.
But you're saying there's an exception for a particular reason, and that reason is because...
Where there is a major or important object of the contract, the purpose of which is to ensure the pleasure and peace of mind of the contract recipient.
I see, sort of a holiday or something like this.
Something like that, and indeed there's previous case law on precisely that point as to holidays. The other matter on this, though, sir, that I hope hasn't gone amiss, is that this contract resulted in considerable distress and inconvenience to the defendant, who was, of course, forced to reside with her parents for a period of some time, with her young family, including 3 children, split as they were, between 2 rooms. And in addition to that, the property was located in Gloucester, not Bristol, and therefore periods of time were had to expand in order to take the children to school. It is a considerable inconvenience, and it is one that the defendant says must be compensated with an award in general damages.
And if I was to rule for you on that point, what sort of figure would you be suggesting?
So there is some previous case law on this point. That the figure is £2,000.
Thank you, Mr. Webb. Is there anything else you wish to address me on?
No, sir, except for the matter of interest. So perhaps it's something that can be covered after judgment. Grateful.
Yeah.
Sir, it is the claimant's case that he actually terminated the contract by accepting the defendant's repudiatory breach. You have heard from the defendant that she changed the lock of the property and left the claimant's tool and material exposed outside unprotected. There is important implied terms of the contract that the employer, the defendant in this case, would not hinder or prevent the builder with the claimant from carrying out his obligation in accordance with the term of the contract and from exacting the works in a regular and orderly manner.
Yes.
By doing what she has done, that she effectively prevented the claimant from carrying out his obligation in accordance with the contract, and she prevented him from finishing the remaining snagging that the claimant could easily complete within time if he could have access to the site.
So what day is it that she puts the is it the same time she has the telephone call? Does she then put the...
Well, yes, it's definitely before she wrote the letter.
Before she wrote the letter?
Yes.
Okay, fine.
And you also heard from the defendant that she did not terminate the contract under Clause 4 as she failed to give 10-day notice.
Well, I mean, I know I heard what the defendant said, but with all due respect to the defendant, she's not an expert in these matters, is she? And her evidence as whether she terminated the contract or not is not really here nor there. That's a matter for me, isn't it?
Yes, it is a matter... my submission would be, it is clear that Clause 4 was not operative in this case. Therefore, the contract, as my learned friend suggested, the claimant case would be the contract was terminated under common law rather than the contract. That's what I want to establish.
What difference do you say that makes? I mean, so we have here either you say it's repudiated, the claimant says it's repudiated, or we have this email that's sent out. What
the difference is who terminated the contract on what grounds, and is the claimant's case that we terminated by accepting the defendant's repudiatory breach by leaving outside, preventing us to comply with our obligation. And there's another factor of this case is to do what that reasonable period of time,
yes,
which we claim that is the implied term of the contract in the absence of any specific completion date.
Yes, it's the Supply of Goods and Services Act, isn't it?
Yes, and you have heard from the defendant that the main reason why she wanted to terminate it because she think it was delayed, not finished on time. But there's no express term. And you have heard from the claimant that the defendant had never communicated that it need to be finished before the expire date of her tenancy agreement.
Yes, I think Mr. Webb's conceded that, hasn't he? What he's saying is that you can take a reasonable period of time to be 90 working days.
Well, however, that is not contested. It was not, it's not, has not been put to an expert. Therefore, both sides fall apart on what a reasonable period of time. And my client, the claimant, is a builder, as you have heard, with quite a good experience on the subject. And his estimate would be 7 months, excluding all the delays, while you have the defendant who is not professionally trained, and with the estimate who she has chance to put in the contract, which she failed to, she admitted in the cross-examination. Therefore, it is claimant's case that a reasonable period of time would be 7 months, excluding delays identified, which was outside the claimant's control. Therefore, the claimant was not in breach of the contract. And as to the damage
Yes.
we are seeking, that we argue that the claimant is entitled to the damage in respect of the loss of gains, which he has been deprived from the defendant's repudiatory breach on the ground. It's the rule of common law that if a party sustains a financial loss as a result of repudiatory breach of the contract, this party is to be placed in the same position with respect to the damage if the contract has been performed. If the contract was not terminated, if the contract had been performed, the claimant would be paid 125,000 in total. That's the contractual fee.
Yes.
Including 110,000 that has been paid on the 24th of December. Therefore, it is claimant's case that he is entitled to the outstanding £15,000, which is both the money due and owed and the damage for breach of contract.
Doesn't that give him a windfall? I mean, so you've got the payment 24th of December.
Yes.
He keeps working until April, but he doesn't finish the work, so he hasn't expended the materials, he hasn't spent the time doing it.
The reason, sorry, if I may, the
Yes.
reason he didn't finish at the time when the contract terminated is because the contract was wrongfully, the contract was terminated due to the claimant accepting the defendant's repudiatory breach. If defendant did not commit repudiatory breach, the contract allowed to be carried on, then he would have time to fix the nagging and finish everything.
I'm unpersuaded by this, Ms. Yeh, because you're ignoring the notice provision in the contract, aren't you? Wouldn't just what had happened, that there would have been a notice given, and it would have been 10 days, so he's missed out on 10 days, hasn't he?
No, not entirely, because the contract at that point, when the claimant went to retrieve the tools, has been terminated. Therefore, the 10-day would not be inoperative in this case.
Very well. Quantum of the counterclaim, I think.
Yes. Well, as to the Mr. Smith's report, that clearly give estimation that the entire work, the remedy work, would have cost £10,000, and the actual try to fix the remedy part would be 5,000. However, it is uncertain. This is the defendant's case that 5,000 clearly is more severe. The work need to be remedied is more severe than just nagging. However, there's no evidence to support that other than a figure. It is not.
Well, and the expert reports.
Of course.
Well, so the expert report commented that something need to be done, but the expert report didn't comment on whether that work will be considered nagging.
No. All right. General damages.
Yes. Well, you've heard that the defendant said that was her dream house. However, she failed to provide evidence to prove she specified ask the claimant to finish the project within specific period of time. Although this, she argued that she lost enjoyment or peaceful enjoyment of the property, but the contract itself is to build a house. The subject of the contract is to build the house, and that needs to be complete within reasonable period of time. And that reasonable period of time was not specified in the contract, which is subjected to your determination in this case. Therefore, we say that we have not in breach of the
All right.
contract terms.
If I'm against you on that and I do award general damages, what would you say is a reasonable figure?
I would say a reasonable figure would be a minimum to very...
1p, £1, something like that.
yes, indeed.
All right. Thank you, Ms. Yeh. Mr. Webb, do you need to come back on anything?
No, I don't, sir, no.
No, thank you. Very well. This is my judgment in the claim of the case of Colin Clement against Danielle Fender, claim number 3PB12345. I have had an opportunity to hear from both the claimant, Mr. Clement, and the defendant, Ms. Fender. I found them both to be honest, truthful witnesses who did their very best to assist the court. I have also been assisted by the submissions of counsel for the claimant and counsel for the defendant, as well as their skeleton arguments, and I am grateful to them for those. The facts of the case are set out in the short case summary, which is at page 9 of the bundle, and I incorporate them by reference into my judgment. The agreed list of issues before me are also at page 9 of the bundle, and I proceed to deal with them in turn. First question is, has the contract been terminated? It seems to me that the parties are in fact in agreement that the contract has come to an end, but they are in dispute as to how the contract came to an end, which moves me on to question 2. Was the contract terminated in accordance with Clause 4? I'm faced with a rather curious situation where, despite having what appears to be written notice, both parties are putting forward as their primary cases that, in fact, the contract was not terminated in accordance with Clause 4, but because of repudiatory breaches at common law. The defendant claims that that repudiatory breach was a failure to complete the build within a reasonable time, whilst the claimant claims that it is because the removal of tools onto the road was a breach of clause, I'm sorry, Monsieur, which clause is it? 21 of the contract. It seems to me a lot of heat and light has been spent on this particular issue. I'm not convinced that, in fact, anything flows from it, but I will make my judgment on it in any event. For the reasons that I will set out later on in my judgment, I am unpersuaded that there was a repudiatory breach of the claimant of any period of time to complete matters. I am also unpersuaded that it was a repudiatory breach, i.e. such a strong breach that the tools were left out on the road. It seems to me that the right approach to take is to find that the contract was terminated in accordance with Clause 4, that was done so by the sending of the email. In that respect, I accept Mr. Webb's submission that there was a breach of contract by not giving 10 days written notice, but that the breach is in effect simply a further 10 days for Mr. Clement to have been working on site. So what, if anything, is the claimant entitled to either as money due and owing or as damages for breach of contract. Now, the claimant says that Mr. Clement is entitled to the entire £15,000. I am unpersuaded in respect of that. I refer to the report of Mr. Smith, and in particular his view that there were completion works that were necessary, which I assume to be in the sum of £5,000. As such, it seems to me that if I was to award £15,000 to Mr. Clement, he would be receiving a windfall, either as money due and owing or as damages, on the basis that he simply had not done that much work. The amount of work that it seems that he did do before the contract was terminated was £15,000 minus £5,000, which is £10,000, and it seems to me that that is the right amount of money that is due and owing under the contract. That leads me then to the counterclaim. Remedial and finishing works. Is the claimant in breach of contract? If so, what is the defendant entitled to? Again, I turn to the opinion of Mr. Smith. I note that it is based on examination of photographs that were taken prior to any remedial works being carried out, and I note that he is a joint expert between the two parties. On that basis, I accept his evidence that there are £5,000 of remedial works that needed to be carried out. To that extent, I find that Mr. Clement was in breach of contract to carry out the works with reasonable care and skill, and I will award £5,000 to Ms. Fender in respect of that. That takes me finally to the claim for general damages. And to deal with the claim for general damages, I firstly have to determine what a reasonable period of time would have been to complete the works. I am in a difficult situation, as it seems neither of the parties have particularly turned their minds as to providing me with any form of expert evidence as to what a reasonable period of time to carry these works out would be. I have the quotation, but I note, first of all, that that is for 90 working days, not for 90 days. I note that there are delays which were incurred, and to that extent I accept the evidence of Mr. Clement above the evidence of Ms. Fender in respect of that matter. And I also note specifically that the parties did not incorporate any particular date within the contract, suggesting that this schedule of works was not intended to be binding on anyone. On the other hand, I have Mr. Clement's evidence as a builder as to what he thought the period of time should be. I accept that he has some experience in this area, but I also note he is not giving evidence as an expert, and I also note that his evidence is given somewhat in hindsight, and that clearly he has a motive in giving that evidence. At the end of the day, this is for the defendant to prove on the balance of probabilities, and I cannot find that she has proven on the balance of probabilities that a reasonable period of time had not been met when the contract was terminated. As such, the claim for general damages must fall. If I am wrong about that, then I accept Ms. Yere's point that this is not the sort of contract that would normally attract general damages in any event. Whilst I am aware that, of course, there is scope to grant an award for general damages in respect of contracts, they tend to be far more contracts in relation to, for example, holidays or other matters rather than the building of a house. I note that it is the defendant's dream home, but I would imagine anyone who was contracting with a builder to build a house would have some emotional investment. That is not sufficient, in my judgment, to attract an award of general damages. It follows from that that I will grant judgment to the claimant in the sum of £10,000. I will grant judgment to the defendant in the sum of £5,000, which means that I will make an order for the defendant to pay the claimant £5,000. Mr. Webb, 14 days?
Sorry, I'd ask for 21.
21 days. Ms. Yeh, 21 days to pay?
Yes.
Thank you. Ms. Yeh, is there anything arising from my judgment?
No.
Interest?
Yes, we would ask the normal court interest, 8%.
8%. I see you've pleaded it under Section 69 of the County Courts Act,
Yes.
so that's in my discretion. Mr. Webb, 8%?
Briefly, sir, 8% is excessive. This is special damages, special account rate, 0.5%.
0.5%. Very well. Well, I'm going to ignore both counsel in this respect. I am going to grant 3%, which I think would be a reasonable savings rate, which would have been awarded in respect of if this had been put in some form of savings account. Ms. Yah, I imagine you're going to ask me for some costs.
Yes.
Where's your cost schedule in the bundle then, please?
My cost schedule is from page 10 till page 14.
I'm grateful. Mr. Webb, I'm aware that my usher is waiting outside with the next case, so we'll try and move quickly.
Yes, well,
Do you have any, first of all, do you have any issue with the principle of awarding costs?
no, sir, costs follow the event. It's not been a complete success, but I don't think I can sensibly argue the point.
No, I would agree with that, so I'll award costs to the claimant. Do you have any comments on this cost schedule?
Well, yes, generally, in the interest of time, I suggest that all of the attendances are excessive. In particular, attendances on opponents at 7 hours is rather high. Likewise, the fee for the hearing of £1,650 is rather high, I'd suggest. And I mean no disrespect to my learned friend and the quality of her submissions in that regard. The general comments as to excess continue to the schedule of work done on documents. In particular, sir, at item 3, 2 hours for reviewing directions.
Give me a sec, Mr. Webb. So we're at what, page 14?
Page 14 at item 3, 2 hours of reviewing directions.
All right, so we've got drafting pleadings 3 hours, reviewing defence 3 hours, reviewing directions 2 hours. So you're saying that's too high?
Yes, indeed.
Okay. Anything else?
And likewise, as we continue down, reviewing disclosure, which would of course be list, an hour to do so.
Well, I'm not sure your client didn't have any disclosure
Well,
in the end.
indeed.
Yes.
So in any event, perhaps that could be cut out entirely. I can't take issue with drafting witness statements. Pre-trial checklists, sir, 2 hours again is an excessive amount for that. Reviewing witness statement can't take issue. Instructions to counsel are perhaps a tad high, but not concerningly so. And then likewise, statements of costs and reviewing bundle and case summary. I don't think I can sensibly suggest that that's excessive.
And the only one you're particularly drawing my attention to is on page 11.
Yes. Well,
Letters out, emails, 7 hours at £217.
yes, sir.
Yes, thank you. Ms. Yeh, do you have anything to say in response? I mean, this is a ridiculous cost schedule, isn't it? I mean, it's £14,000 for a claim of £15,000 is somewhat high, isn't it, a touch?
Well, sir, with due respect, my instructing solicitor put work into it to try to settle the matter, and therefore I would submit that 7 hours attendance on the opponent is not unreasonable, but show a great effort and try to engage the other side. And I took on my learned friend the point at page 14 in regards to the disclosure. However, that although the disclosure, well, there's still certain documents that she disclosed in terms of the contract or anything that will require time to deal with. And then the review of direction also necessary as to the checklist. Is just show that the prudence of the claimant solicitor try to deal with the matter effectively.
Thank you. Well, it's my judgment that costs should be awarded to the claimant, and that I will summarily assess those costs. I remind myself that costs have to be both reasonable and proportionate, and in my judgment, these costs are neither. I particularly note the excessive amount of time spent on correspondence with all parties. I also, although it's not been brought up, I know that the fast-track trial fee for barristers is commensurate in relationship to how much is awarded. So I think it's £690 for £5,000. Is that right, I think?
Yes, that's my
Yes,
understanding.
yeah, lovely. But given it's a summary assessment, I am simply going to assess these costs at £5,000 plus VAT. 21 days for that as well?
Yes,
Yeah.
sir. Yes.
Thank you. In respect of the interest, I would ask the advocates to calculate that, and if you could draw up an order for me and send it through, I would be very grateful. Thank you. Are we done?